Good afternoon. This is Hope Roski with The Wedding Show. And, it's February 28th, and I know we've been in a drought, but it's been rain, rain, rain. And hopefully the sun will come out. That's why, hence this color. I've got to get a little uplifting here. Talking about some things that we need to start thinking about in the future. Have you ever thought about what it means to have your future planned out, and when you get married, what you need to do to plan an estate? Well, today we are very fortunate enough to have the leading estate planning attorney here in the Valley, Phil Flanigan, who I was fortunate enough to go to high school with. I was a few years younger, of course, though, right, Phil? Tell everybody. Yeah, a couple years. There you go. Anyway, Phil is here to talk to us today about what it means when couples join in union to plan an estate. So, Phil, can you just describe to everybody some of the things that newlywed couples need to think about as they move forward, and what this means for them?
Sure. I mean, it's really, first of all, thank you for having me.
Oh, sure. Absolutely.
When couples get married, one of the things that they probably don't think about is passing away or becoming incapacitated. And unfortunately, we know that sometimes that does occur. So it's extremely important to have some estate planning documents in place that enable other people, including your spouse, to be able to make decisions for you if you're incapacitated, or to specify who's going to be in charge of administering an estate, and where the assets are going to go if something unfortunate were to happen.
And I think that's, one of the things is, everybody thinks about the big day and their happiness, but sometimes you just don't know what life has to offer. And even moving into your first year, accidents can happen, things can occur. So having something like this in place is essential. So people talk about the difference between a will and a trust. Can you describe what that difference is? Because some people say, oh, I'm just going to do a will, and other people talk about will and trust.
Right. What I always tell my clients is, what a will's doing is giving you the opportunity to have a say-so in who's going to be in charge of administering the estate when you pass, also specifying who the assets are going to go to. A living trust is designed to do primarily the same thing. The biggest difference between the two is how the transfer takes place. So, for example, if you own your home and your name is the only name on title, we need you to sign a deed in order to transfer ownership. So even though you have a will that says when you pass, the house goes to me, well, that's great, but how do I go about getting that house put into my name? I need you to sign a deed. Well, if you're deceased, obviously we have a problem.
Yes, one would.
Now we have to go to court, and we go through this process called probate. With a living trust, the key step is we're going to transfer ownership during your lifetime from you individually to your trust. Now the signature that we need to transfer ownership is the signature of the trustee. While you're living, that's still you. So nothing changes during your lifetime. It's still your house, still your assets. You can still do whatever you want with them. However, when you can no longer be the trustee due to your death or your incapacity, now we have a successor trustee who steps in, and that's who can provide the needed signature. Because of that, there's no need for us then to go to court. So it allows your assets to be administered much quicker, much less expensively than having to go through the probate process.
So that's one of the key words that you used, which some of our viewers may not be familiar with, and that is the probate process. Can you describe to our audience here what that might mean for them if they don't get this lined up, and what they may have to face?
Yeah, sure. Again, the reason we have to go to probate is because we need a signature that we can't get. It's really that simple. If I don't need you to sign anything in order to gain access to your assets, I don't have to go to court. And a prime example would be something like life insurance or a retirement account where you have a beneficiary. If you pass away, I don't need you to sign anything. I just need to establish that you're deceased with a death certificate, show that I'm the beneficiary with my ID, and the money gets transferred. However, when I need your signature on something, an account or real estate that's in your name, now we have to go to court and go through this probate process. Probate is the court process which we have to go through to clear title. The problem with probate is it's very time-consuming and it's expensive. Most probates, I always tell people, have costs somewhere, hard costs somewhere in the vicinity of $2,500, maybe $3,000, which is not a huge expense. But when you get into legal fees, the legal fees are based upon the value of the estate. And it's based on the gross value, not the net value. So an example, if you had a $200,000 home and you owed $180,000 on the house, the probate fee is still based on the $200,000, which in that case would be $7,000. So it's very expensive.
Yes, and
But-
that's important for people to understand that, because they're going to think, well, this will just kind of happen as it goes, but they really have to start thinking ahead.
Right. And I think, cost is something that's important, obviously, for us to consider. But what's really critical for most people is how long it takes. And I can tell you right now in Fresno County, it's a real problem because ever since COVID, we are so backed up in our courts that probates are now taking well over a year from start to finish. So that's a good year before your beneficiaries can receive the assets from your estate.
My goodness. So it's really looking at being proactive versus reactive in a situation like this. One of the things that people need to think about too is, what does power of attorney mean? What does medical power of attorney mean? And maybe you can describe that and why that's also key to have in place as
Sure.
well.
And what I tell people, everybody over 18 should have some basic estate planning documents, even if you have no assets. And unfortunately, a lot of times when we talk about estate planning, people think of, well, gee, I don't have an estate, because estates are those, big houses with big, huge iron gates and, people with lots and
Right.
lots of money, and that's not me. Well, that's not most people. However, everybody over 18, now you're an adult in California, your adult children, now that they're over 18, can no longer depend upon you to make their decisions unless they've given you some kind of legal authority to do so. So even though your daughter may still be living in your home, the fact that she's 19 years old, you can no longer make decisions for her. You have to have some legal documents that authorize you to do that. A financial durable power of attorney is going to give whoever you appoint the ability to handle your business and financial affairs if you're incapacitated. And an advanced medical directive is appointing someone to make medical decisions for you if you can no longer make them for yourself. It's not divesting you of your ability to act for yourself. It's just appointing someone else who can act for you in the event you can't.
And
So
these are
extremely
very,
important.
it is important. And, this goes out to all the viewers watching, whether you're getting married or not. If you don't have something like this in place, I think it's, very essential that you take the time to investigate and look into it. One of the other things that I wanted to talk to you about as well, as some couples are getting remarried, and so they're blending families. How does that, because now we're getting into maybe some sticky wick dynamics, but I think it's also important to have an understanding with that too.
Well, you definitely have to have the conversation. And anytime you're entering into a second marriage, especially when you have children from prior relationships, extremely important to understand what happens if you passed away and didn't have a will or a trust, and how you can structure your estate plan to make sure your assets do go where you want them to go. The other thing I think that a lot of times people have confusion over is the nature of the assets being separate property versus community property. A lot of times people erroneously think that, well, since we're married, everything's community property, and that's
Yes.
not the case.
Right.
If you have assets that were yours prior to the marriage, they are your separate assets as long as you keep them separate. However, earnings during the marriage are community property, absent some kind of a prenuptial agreement. And so, yeah, anytime you're getting into those types of situations, I think it's extremely important to spend the time, sit down with somebody like myself who can, throw out scenarios, get you to think about the what ifs. What if this happened? What if that happened? So that you actually contemplate some things that oftentimes you wouldn't think about. The other thing that I think is extremely important to talk about is planning for your children. If you have minor children, probably the most important thing you can do is to make sure that you've nominated guardians in the event something happened to both parents.
Absolutely.
So, I always tell people the first time I ever did a will for myself, I think I was 26, 27 years old, and, what do I need a will for, right? But we had friends who were killed in a private plane crash, and there was a huge custody fight afterwards over their children. And that is something that you never, ever want to have happen. Obviously, it's a horrible time in the child's lives.
Right.
Now to be in the middle of a custody battle on top of that just made things even worse.
I can't even begin to fathom something like that. And that's why it's important to take the time for people to do this. So if people have questions and they want further conversation with you, how are they able to get in touch with you?
Easiest way is either go to my website, which is the pmflaw.com, or you can call us at 435-0455, schedule a free consultation. I always am willing to meet with people for up to an hour to go over estate planning concepts in general and answer their questions.
And I appreciate you sharing that. And that's wonderful that this is a free consultation for people. And I think that's something to definitely take advantage of. Before we wrap up here, you had mentioned the word prenuptial. Can you describe a little bit about what takes place? Because that's also another sensitive subject that conversation may have to occur. So can you describe that a little bit?
Yeah, we don't do a lot of that, but obviously if you're entering into a relationship later on in life and you have assets that you've acquired previously, sometimes it's really important to discuss how to keep those assets separate. What if the marriage didn't work out? Whose assets belong to whom, and if they're commingling, or when you're paying for the house, my payments towards the house, is that making it community property or is it a gift? And so premarital agreements basically are designed to solidify the arrangement between spouses, so that in the event there is a later breakup, they've already talked about how the assets are to be divided.
Well, thank you so much for coming in today, especially driving through this weather that we've had. Surprised you didn't take your boat coming in. But anyway, again, this is Philip Flanigan with the law offices of Philip M. Flanigan, and if you would like to reach out to him, please do so. He is educated, has wonderful information. Take the time to do it. It was great to see you again after all these years. All
Absolutely.
right.
Thanks, Hope.
And we'll catch you right back here in the next few minutes. This is Hope Roski with The Wedding Show.